Yes. As you may already know, 4IP Council is a non-for-profit research council developing high-quality academic insight and empirical evidence on topics related to intellectual property and innovation. 4IP publishes rigorous independent research on intellectual property available free of charge. The presentation will be followed by a 15-minute Q&A. Now, slide 2. Please allow me to introduce to you our great speaker, Matthew Heim. Matthew is an independent policy counsel and advises clients on managing legal, regulatory, or political risks and crises. He is a senior advisor to 4IP Council and a visiting research fellow at Bruegel. Matthew's presentation is based on a research paper co-authored with Dr. Igor Nikolic, which was published by JIPITEC in May 2019 and got the Best Telecom Research Paper Award from the FRAND School of Regulation just last week. The presentation will be made available on 4IP Council website after this webinar. Also, please feel free to subscribe to our newsletter to receive updates on relevant academic studies, future webinars, and case law summaries. And now, without further ado, Matthew, the floor is yours. Okay, I'm going to give my microphone to Matthew.
Yeah.
Apologies, everybody, for the brief glitch. I hope you can all hear me, and if not, do let the organizers know. So I wanted to give you a very quick introduction to some of the research that my colleague Igor and I had done, looking at some of the European legislation that has adopted a FRAND access model. Now, in order to make things fairly straightforward, I'll go through a little bit of introduction, then review some of those pieces of legislation and European law, and then come up with some conclusions, pulling together the overarching elements that we have found. Very quick introduction to the context of the research. As I'm sure a large number of you will know, there has been a debate on what is FRAND. It's been raging for at least a decade and a half, maybe longer. And it is mainly focused in the context of standards essential patents, which is obviously a hot topic. But rather interestingly, we hadn't seen a review of FRAND-based legislation. And so we thought it might be an interesting exercise to see how other regulatory structures had adopted FRAND-based access regimes. So we have looked at a whole raft of European legislation on that basis. The spur for this was a consultation which DG Competition run at the end of last year and throughout the earlier part of this year, based on some work done by the expert group to Commissioner Vestager, and a report released fairly recently on dominant digital platforms, which if you're not familiar with, you should read. It is a very interesting document. But what we did find is looking at some of the challenges relating to digital platforms was a level of commonality on some issues. So, for example, without a doubt, highly complex, very dynamic markets, questions about access to intangible products and critical or essential inputs, situations where market power was sometimes presumed but could not be assumed, recognition that compulsory licensing in itself was a rather radical tool and therefore maybe not the right approach, and also, of course, most importantly, the need to maintain some form of incentive to invest. It is not just about access, it's about balance. And so given these parallels, we decided to take a look at the situation. So we've looked at European competition law, not in too great a depth because it's an area well known, and there is an awful lot of writing on these topics. But we also looked at 9 pieces of European legislation. Oddly enough, I don't think this has been done before. At least we hadn't seen any legislation, any review in any depth of such legislation. But before getting into the guts of the report, there are a few caveats. First is this is not an exhaustive review, so there may well be other pieces of legislation and regulation that you know of that we won't find. We don't, fairly importantly, make any statements on notions of market power in relation to digital platforms, partly because it is a very hot, controversial issue and is a whole report in itself. Nor, given the fact that there is a significant amount of heterogeneity between different kinds of platforms and different types of data, have we tried to actually apply our findings, because again, we would have to start to take very, very different models, and this is a very significant piece of work, so we leave that to others to do. And then finally, we did look at how the FRAND regime worked in certain markets where the FRAND regime had been set up through legislation, but this would be a new area of research and potentially quite an interesting one to see how it had worked on an ongoing basis. Having said all of that, I think we can get into the report itself and to look at some of these FRAND elements. So the first part is look at European competition law, European competition policy. Again, this is something that a number of you will know extremely well, so I'll skate over this. But the first point is if you look at Article 102 of the treaty, which touches on abuse of dominance, it is actually FRAND-based. If you look at the basic principles underpinning the treaty, in other words, it prohibits excessive pricing, it promotes access, promotes innovation, and importantly, especially following the case law of the Court of Justice, promotes non-discrimination. So rather intriguingly, the very underpinnings of European competition law when it comes to unilateral conduct is FRAND-based, even though it may not be expressed exactly in those terms. Having said that, FRAND has a long history in competition law, mainly when it comes to unilateral conduct in the context of compulsory licensing. So in all the major compulsory licensing cases, of which there are comparatively few, FRAND-based remedies were applied to ensure access to the essential input at stake. And importantly, the regulator did try to avoid being the price setter, and so the FRAND regime enables the regulator to avoid being a price setter, which is a very important factor to bear in mind. Having said that, as you are undoubtedly aware, there are actually very few compulsory licensing cases, and I don't think there are many who would argue that compulsory licensing should be the main approach, but it is interesting to note that FRAND was adopted in this context. More interestingly, however, is the approach that we see in merger policy and merger cases. And if you investigate this quite closely, you'll find that FRAND remedies have occurred in a large number of European jurisdictions, so at the national level as well as non-European around the world, and in many, many sectors. So not necessarily the classic sectors that one would think of, but as listed here, medical equipment, TV broadcasting, payment processing, gas, flight search, even missile systems, herbicides. So very, very broad. And I think this shows flexibility that the FRAND regime has been seen to provide. Now, another important point to mention is that these FRAND remedies, notably when it comes to interoperability and when it comes to digital markets, are not simply a requirement to grant access for a price, but also include a package of remedies to make the access reasonable and feasible, including obviously APIs, but also software updates, data management systems, and any other elements that are necessary to keep the access available over time. So I won't run through all the cases. They're listed in the paper in greater detail. I've just in this presentation put down 3 cases. Worldline Equins is probably the best known case, but actually there are cases going back a decade and more. Notably, News Corp is a very interesting case worth looking into if this is an area of interest to you. Now, there are, of course, a number of pros and positive elements when considering some form of FRAND regime under competition law. There are also some cons, which I'll get to in a second. It's not all rosy. The first is obviously that the FRAND regime is, in a sense, fairly unintrusive. It is a requirement to grant access, but those terms are based on what the market usually bears. Particularly useful when there is no regulatory framework, although actually it has been applied, for example, in News Corp, where there was a regulatory framework, but the feeling was that we needed an additional safeguard measure to ensure access. And as I mentioned before, it does ensure that the regulator doesn't have to get involved in price setting, which is extremely difficult and highly contentious. And in past cases, in fact, the European Court has probably indicated that whatever price a regulator comes up with, they may well get it wrong. As noted, these remedies should be based on existing practices if they do indeed exist, and as I mentioned, franking measures. And most importantly, it's not one-way traffic. It is a balance of interests, and I think most importantly, and we'll see this further in some of the regulation and legislation, there is an attempt to ensure that both parties in the equation have equal bargaining power, which is precisely what the regulatory framework in these contexts seek to ensure. But as I mentioned, there are also some slight negatives. While merger cases can be very instructive and useful, and frankly, if you are interested in this area, I would recommend you read the decisions because the remedies are in quite a lot of detail. But of course, merger remedies require merger filings and therefore are haphazard and are not best placed to assist in regulating the sector. They are naturally case specific. And so it is sometimes quite difficult to extrapolate broader notions that would help a whole sector, because the remedies will be tailored very much to the nature of the company or companies proposing them. But of course, when we come to conduct cases, there are very few of them, they're fairly slow. You wouldn't wish your case to be used necessarily as a sort of policy-making vehicle, and therefore not entirely ideal from that perspective. And frankly, where remedies are extracted through an Article 9 commitments procedure, the precedential value is limited. And so the use of competition law as a regulatory tool has some definite limits to it. There is, of course, an additional aspect, and one, as I mentioned before, quite well known, and that is the approach that competition law is taking specifically to standard essential patents. The leading case is one that comes from the European Court in Luxembourg, and essentially some of the conclusions that can be drawn from it is that it sets out a process which, if both parties follow the process, will result in a FRAND outcome, and that if either party does not fulfill those essential requirements in the process, either there is an antitrust defense, or or competition law defense to the seeking of an injunction, or an injunction may be available if the other side has not followed those steps as well. So again, we see the court, and interestingly enough, actually, it'll be reflected in legislation that precedes the case, taking a very balanced approach. We also have the horizontal guidelines, where the Commission clearly sets out that standards organizations that have a FRAND commitment enable the creation of a safe harbor. And then finally, and then I'll move on, I hope, to what I think ought to be the more interesting part of the presentation. Finally, we have the approach to of competition law to de facto standards, which is also applied FRAND access regime, both at the European level, in one of the Microsoft cases, and in the famous German Orange Book case. Finally, actually, if you do read the conclusions of the expert report, they do mirror some of what I've just said, some of the conclusions of the paper that Dr. Nikolic and I put together. And that is that, yes, indeed, FRAND can be a useful complement to provide access, and has to be looked at on a case-by-case basis, as I mentioned, but there is probably no surprise there. So moving on to regulation, should really be regulation and legislation. So we look at 9 pieces of legislation where some form of FRAND access regime is discussed. And you will see that it covers many sectors, many forms of legislation as well, so both directives and regulations and others. As a quick breakdown, we try to give you a sort of a quick overview, although I will run through some of these pieces of legislation. But you'll see that the focus of the FRAND access regime covers everything from patents to data to networks, research results, and frankly different forms of data, as well as information held by libraries and others. Some of them actually refer to FRAND, so fair, reasonable, and non-discriminatory conditions. Other pieces of legislation don't specifically refer to those words, but may refer to them in a broader context, and you'll see some of the wording later on, but pretty much reflect the same notion, and we can get into that in some detail later on. In terms of pricing elements, there are pieces of legislation that give senses of parameters. None of them give a price, which doesn't surprise me, but a number of them provide guide points as to what may or may not be reasonable. Interestingly, 4 of those do talk about the importance of transparency of terms, sometimes terms up front in detail. But importantly, not all of them, in fact, very few of them talk about market power in any meaningful sense. The one that does, which is the benchmark regulation, actually occurred after a series of cartel cases where clearly there was some concern about market manipulation. So in general, these are not competition focused, and therefore provide a very intriguing perspective to look at FRAND access regimes. So I said I'd run through the legislation bit by bit, but I'll try not to dwell too much on each slide. And as I said, it's all you'll find the details in the article and the footnotes. So the first piece of legislation, and I frankly, they are not listed in any particular order, but the first piece of legislation is the one that links, I think, competition nicely back to the sort of regulatory framework, is the EU standardization regulation. The function of that regulation was to ensure that certain forms of technical specifications developed outside the formal standards organizations of the EU could be recognized for public procurement. and in order to be recognized, one of those elements was to ensure access on FRAND terms. And so you'll see that this actually just reflects WTO norms, so that nothing particularly revolutionary here. There is a reference to licensing of intellectual property without compensation, as well as for compensation. I think this is a nice reflection. FRAND includes royalty-free, although of course royalties is not the only form of value consideration may flow in an agreement, as I'm sure you're aware. The second one, more comprehensive, is the Electronic Communications Code, which goes into a fair amount of detail. Now, I should, of course, have added that the FRAND elements in these pieces of legislation may not be the core of the legislation, but as far as access is concerned, will be. So obviously, the European Electronic Communications Code does an awful lot of stuff, but where access is concerned, you'll find that it's based on FRAND. The code is long, complex, and touches on many access obligations, but as I said, it's FRAND focused. It is enforceable by regulatory authorities. It's actually, I think, one of the only forms of FRAND regulation or FRAND access regimes which has a regulatory body overseeing those provisions. It does focus on significant market power, which, not exclusively, but in some instances, which, as I'm sure some of you know, equate market power in general in a competition context. Again, not exclusively, so only in some instances. And so I think we've yet to see this lid. This is one of those areas where it would be actually quite interesting to go down into the markets and see exactly how this has worked or not, but we've certainly seen no kickback against that. The Horizon 2020 research framework is a very interesting piece of legislation from this perspective, because it actually fleshes out what fair and reasonable conditions actually means. It's, I think, one of the only pieces of legislation in this list that does so. And what is particularly intriguing from this perspective is that there is only one definition of fair and reasonable conditions. It applies to all scenarios, so whether or not access is granted between project participants or to third parties or affiliates. So that in that sense, no distinction is made. And that is not a surprise, because FRAND is particularly flexible, as we'll see. It allows, depending on the specific circumstances, the access to be provided, and the value of the, or potential actual value of the results is one of those terms that help in providing some guidance on value. The next, as I said, I'm going to run through these rather quickly. The next piece of legislation was a credit ratings agency regulation, which it takes a slightly different approach, and rather than setting out what FRAND is, certainly sets out what FRAND isn't, and therefore that a fee cannot be charged on the basis, for example, of the level of the credit rating, but therefore has to be based on costs. Now, some of these pieces of legislation talk about cost, notably, for example, the reuse of public sector information, but that is due to the nature of the provider of the resource, rather than potentially the value. So you'll see that where the resource or the input requires time, effort, and investment, you do not have an actual cost reflection. The vehicle emissions regulation is one of those pieces of legislation you have to really look for to find. The FRAND element is not obviously the most important part of that, but where vehicle manufacturers vehicle manufacturers have to provide maintenance information, and there has to be, I mean, they can charge a fee, but it has to be reasonable and proportionate. And certainly not so disproportionate as to discourage access. So that's, again, a sort of slightly different perspective of what reasonable is, and I think quite useful. So it certainly should not discourage use. Then we have the reuse of public sector information. And again, you have to bear in mind that these are public bodies who are providing access to information. So, for example, libraries is a good example. And so the notion of what is a reasonable remuneration is very much limited, as is expressly said, to cost, collection, production, reproduction, and dissemination. But there is the ability to charge fees to non-public bodies. So where the exchange of information or provision of this information is to another public body, fees are very much limited. But when it is to a private body, especially one that may wish to apply commercial use to that information, well, that changes things. And so there's a fairly pragmatic recognition of that fact. Reach, again, this time in relation to the sharing of reports, looking at the registration of chemicals. And there is clearly a significant public policy element here to try and ensure that past work can be reused and the system of registration be made more efficient. And so here, as in many other areas, you'll see a very significant public policy element in the desire and the intention to use an access regime in particular. I'll scoot over this one, but it's also available in the Payment Services Directive as well. So now I'm going to go on to the analysis in a few minutes that is left, and maybe this is hopefully the most interesting part. So as usual, hopefully the most interesting is left to the end. Having looked at 9 pieces of legislation that spans such a broad range of sectors and access requirements over time, frankly, and so some of them are actually fairly old, some of them certainly predate, for example, the Huawei ZTE case that I mentioned earlier. I think it's fairly safe to say that FRAND is a general principle. And the reason that I say that is that although in some pieces of legislation you will find FRAND as in the exact wording, in many of them those exact words in that exact order is not there, but the result is essentially the same. And I think that you'd have to be very brave to try and interpret the result differently depending on the wording. What I think is clear is that that a number of these sectors have come across this form of wording or this form of approach in a rather haphazard fashion, and that leads me to believe it is a general principle that is easily pulled together. So, as I've mentioned, it's used usually in a legislative context or regulatory context rather than enforcement, to promote particular public interests and public policy imperatives. And these are very, very broad, ranging from the sort of access to information all the way to environmental concerns. And if you read the recitals, it becomes quite clear that public policy requirements for access to certain kinds of essential input is a pretty strong element to those pieces of legislation. Interestingly, it applies to both private and public bodies. Public bodies we can more or less understand in that they also fulfill clearly public interest tasks, but it is intriguing to see that applied to private bodies as well, very, very broadly, and also to both regulated and unregulated sectors. In other words, in unregulated sectors, it is a useful and flexible form of soft regulation. And again, you find it in all forms of documents and legal texts. And again, not to belabor the point, but it is true that very few of those focus on market power or any form of similar notion. And indeed, in a number of pieces of legislation, we're not actually talking about essential input or indispensable input for market access or activity, but just for public policy purposes. So actually you have a very broad spectrum of access requirements. On the competition side, in certain cases, it is an essential facility, all the way to essentially a nice to have, but in the event that it is a regime to be followed, then FRAND is applied. So eminently flexible. So very quickly, when we talk about fair and reasonable, you have different notions of what the terms could be. So as financial terms, compensation, income, charge, and I think that very much depends on the value transfer, depending on the nature of the sector. But all of them, except for well, actually even, I should say, the reads of public service information emphasize the balance between cost and investment on the one hand and use and access and the interest of the parties. And so it is, as I said earlier, not by no means one-way traffic. It is very much a balance. Non-discrimination is obviously clearly there, sometimes pretty elegantly expressed, and without a doubt a recognition that not all situations are alike, and in those situations, it is not a question of discrimination. One of the elements that does come up quite regularly is that of transparency. So it is a notion not linked specifically to obviously FRAND, but to making FRAND effective. And interestingly, very often reflected prior to Huawei's ETE. So for those of you that don't know, in Huawei's ETE in that decision, the European Court of Justice made it clear that in making a FRAND offer, the essential patent holder had to describe in detail which patents were at issue and what the royalty requested was and how these were calculated. So a very significant transparency requirement, which is partly reflected too on the implementer, on the potential licensee, but actually in the reuse of public sector information and in REACH, which predate Huawei's ETE, those are also there. So I think, again, a general principle. Again, very quickly on dispute resolution, a number of pieces of legislation require both parties to act in good faith, again, not one-way traffic, and that there is no requirement to go to arbitration or other, but actually, although alternative dispute resolution mechanisms are available, ultimately the courts have the final say if push comes to shove. And so I think as a penultimate slide, it is quite clear that looking at all these pieces of legislation and drawing all the conclusions and inferences that one can, FRAND has been applied, again, across a number of sectors, sometimes in I think one can say an uncoordinated manner, but it's quite clear that one can pull together these themes to identify that FRAND provides a good balance. It is proportionate in that it does not distort commercial relations and has a very pragmatic approach. So given that, I thought I'd leave you with this final slide because it helps to concentrate the mind, and I will leave the floor open for any questions and pass over to the chair.
Many thanks, Matthew, for this very excellent overview of the FRAND access regime in European law. It's now time for Q&As. And should you have any question, please type them in the chat box. And I see already a couple of questions. So I'm gonna take the first three and then we're gonna see if we have more, okay? So the first one. Has the European Commission not done such a study before?
Yeah, no, that's a very, very good question, actually. I was quite surprised to find the answer is no, at least not public, or at least not that we could find. There is a communication, I think it's 2017, on data sharing, which does cite a number of these pieces of legislation. By no means as full as you'll find in our paper. And rather intriguingly, they immediately focus on the SEP question, and therefore, I would say somewhat discount FRAND. And I think that is not an appropriate response necessarily, because if you actually dig a little deeper, you find quite quickly, as our research shows, that the FRAND examples that we see across different pieces of legislation are actually quite useful in identifying means of sharing access to documents. So I think there was maybe a little bit too much of an SEP hang-up, which is quite specific. And I think I would add, the reason for this is probably because in the context of the sharing of information under the legislation that we highlighted will essentially occur once the terms have been agreed, because that information is held by the input holder. In the SEP context, the input is already shared, and it's essentially ex post that access that the terms are discussed, and that may well be why there is more dispute, because it is easier to leverage those disputes.
Thank you, Matthew. So I have two more, and I see that more online. So did you find any particular differences between FRAND regimes dealing with indispensable inputs and access to platforms?
I think actually, so often these were blurred in that once there was access to the platform, there was also access to data that platform provided. I think the main difference, though, is that that when it came to access to platforms, it's not a simple question of making sure that the terms and conditions are correct. The merger remedies here are particularly insightful because they demonstrate that a package of remedies or package of conditions have to be put forward in order to ensure that technical access works efficiently, effectively, and over time. So updates, upgrades are very, very important, usually royalty-free, so there is no sort of surprises down the line. And I think that may be the biggest difference.
Thank you, Matthew. So I'm taking two other questions, and after I will check because they're coming. About Horizon 2020, do you see a similar FRAND to fair and reasonable condition? I think we might need a bit of more explanation on the question, but that's the question.
If the question is whether terms and conditions are the same, I would say yes. I wouldn't, in this context, I don't think an interpretation of the words is particularly helpful. I mean, the point is that if access is to be granted, it has to be granted on conditions that are feasible and reasonable. Now, these may be monetary, but or financial or compensation, but it's also in terms of providing access over a reasonable period of time and not delaying access to information in that sense, or providing it in a format which is not usable. So I think that FRAND incorporates all of that. Of course, the nature of the conditionality is dependent on the nature of the input. If it's provision of data, it has to be provided in a form that a program, which is generally used in the industry, can read it. I think that's if that's the question, that's the answer.
Thank you, Matthew. So 2 more questions, and I'm going to try to simplify them. So I hope that I will capture the essence of the question. What is the advantage of FRAND compared to the essential facility doctrine?
Well, that's actually quite straightforward. I mean, they're not in conflict, in that you can, once access is required, FRAND terms is usually the regime applied, but obviously the essential facilities doctrine is a legal doctrine which, frankly, in a number of jurisdictions is really not considered appropriate, notably in the US, by the way, but I think in Europe it is at least recognized by the Court of Justice. But the essential facilities doctrine essentially is a compulsory licensing regime, which implies that the input that the holder has is critical, and therefore they lose certain property rights over that. And that is a very draconian approach, and should only be used in exceptional circumstances, which is why we've only seen it applied in competition law in Europe, at least at the European level, once every decade or so. When it has been applied, it has been through the FRAND regime. So in a sense, these are slightly different. The real question is, if we don't apply essential facilities, then what is the legal requirement for sharing? And that is, as we've seen, in a competition context, highly controversial and is being debated. And in the regulatory context, it depends on the public policy. Some public policies are so significant that essentially we have a form of essential facility because the legislature has deemed it to be that important, but at least it goes through the legislative check and balance.
Thank you, Matthew. So I have another one. It's a tricky one, okay, and very long one. So I'm going to try to capture as well against the essence of the question. So FRAND and artificial intelligence. And so the person is mentioning that FRAND is mentioned in the AI expert group recommendation, and as well in the recent report from the advisor of Commissioner Vestager. And so the question is, if I understood correctly, should FRAND be used to go after big tech companies?
I would put it differently. In the FRAND is not a tool to go after somebody, as I said. So we made, frankly, Dr. Nikolic and I made our lives easy. We decided that the state of the law at the moment is not entirely clear in relation to, let's call it big tech, for want of a better word, which is a rather nebulous notion. And for that reason, it is difficult to pin any legal theory down. As I said earlier, or at the very beginning, dominant platforms are heterogeneous. In other words, if you talk about a platform as the market, if a company has market power, it is pretty much unique in its market, and therefore the remedy for any abuse, if abuse is established, will have to be tailored for that market and for that abuse, which is fairly straightforward. But if the remedy is access, then FRAND provides a very useful metric, which has now actually a fairly long history in European law.
Thank you, Matthew. So I see no other questions. So I'm going to ask the audience if there are any other questions, because we still have a couple of minutes to benefit from the knowledge of Matthew. So I'm just giving 1 minute to the audience if they have any question, and otherwise we will close the call, okay? Matthew, anything else you would like to say while we're waiting for the audience?
Apart from thank you for your patience in listening, and I hope you found it insightful and useful. And you'll find, if you need if you have any burning follow-up questions, let me know. You'll be able to find my details online.
Thank you very much, Matthew, for your very insightful presentation. So an email will follow with the links to download the presentation, the research paper, as well as the recording of this webinar. And I hope that the beginning won't be too noisy, I would say. Thank you all for your participation to this webinar. And please note that the next 4IP Council webinar will be in September. Enjoy the summer break and bye for now.